Hello viewers, welcome to Ekam Academy. Today in the Concept of the Day series, we are going to discuss about Article 32, which is talking about the concept of writs. So what are these writs, from where we have borrowed, what type of writs we have, and what is the purpose of each writ, and what is the difference between the writ jurisdiction of Supreme Court and High Court. All these are the things which we are going to discuss in this particular video. So first, let us discuss. So what is the constitutional remedy? So we know in Indian Constitution, in Part 3 of Indian Constitution, we have a set of fundamental rights guaranteed to some citizens and to all citizens and some persons also from Article 12 to Article 35. But in case if these fundamental rights are being violated by the state, then you can approach to judiciary and you can ask for their enforcement in the form of writs. So that writ is nothing but a constitutional remedy guaranteed by the Constitution itself to enforce your fundamental rights. So a fundamental right is actually given to enforce all other fundamental rights. That is what the concept of writs. So let us understand the right to constitutional remedy. So this is guaranteed under Article 32 of Indian Constitution in case of any violation of your fundamental rights. So if any fundamental rights gets violated, then you can go to judiciary, that means here Supreme Court and High Court, and then ask for issuing of writs. So if this writ is issued, then you can ensure that your fundamental rights are getting enforced. That is the main object of right to constitutional remedy, which is itself also a fundamental right. Then let us understand what is the concept of writ. Writ is nothing but an order or a decree issued by a court. So it was borrowed from UK Constitution in the name of prerogative writs. Prerogative writs are actually taken from UK Constitution. Same thing was actually inscribed into Indian Constitution also. Then what is the main purpose we have understood? Then who can issue the writs? Under Article 32 of Indian Constitution, Supreme Court can issue writs, and Article 226 under Article 226, High Courts can issue writs. But apart from these, Parliament is also empowered to issue or to confer the power on any other court other than Supreme Court and High Court to issue writs. So, but this power is not exercised so far, right? So any other court also can be empowered by Parliament. Let us understand the types of writs. So we have 5 types of writs. So what are those 5? Habeas Corpus, Certiorari, Mandamus, Prohibition we say, and Quo Warranto. So these are all Latin terms. Let us understand one by one. So first one is Habeas Corpus. So Habeas Corpus means to have the body of, or to produce the body. So that means if a person is illegally detained, so to produce that particular person before the court in case of any illegal detention, we can exercise this particular writ. So if you have watched any movie where the particular person is actually arrested without proper reason or beyond that particular time, if he was sentenced in jail, then habeas corpus can be generally issued by the courts. So what is the situation? You have to understand this habeas corpus can be issued against both public and private authorities also. And in which situations it will not apply, that is also important. If the detention is lawful or legal, then also you cannot issue this particular thing. And if that jurisdiction is out of the court, that means if that particular court is not having jurisdiction to issue the writ with respect to that particular case, then also habeas corpus cannot be issued. And the same time, if that is detention related to contempt of court, then also habeas corpus cannot be issued. So these are some exceptions related to habeas corpus. Let us understand second one, that is mandamus. Mandamus means to command. So what are we going to command? Judiciary is going to command that a person who is failing to do his duty, that person will be commanded to perform his duty in the name of mandamus. So this is generally applied only for public authorities. You cannot issue mandamus against private authorities. So very much important, mandamus is trying to promote some activity where the person is failing to do, right? Let us understand more about next one. Next, we have prohibition. Prohibition means to forbid. That means in some situations where the higher court is issuing prohibition to the lower court to prevent the particular court from accessing or from crossing its limits or from crossing its jurisdiction, then a writ in the name of prohibition can be issued. For example, if the lower court is crossing beyond its jurisdiction or if it is crossing its jurisdiction limits, then this issue of prohibition can be exercised by higher courts with the name prohibition, to forbid, right? So this is generally exercised only in case of judicial bodies. It cannot be issued against any administrative, legislative bodies, you have to remember. Then mandamus is trying to command some activity, whereas prohibition is trying to promote some inactivity. That means you are stopping from doing something. Understand the difference. Then we have certiorari. Certiorari means to be certified. What does this mean? That means in some situations where there is no jurisdiction for the particular court, okay, or in case of some like situation where the court is not competent to try that particular case, in that situation you are trying to stop that particular thing, or you're asking that particular court to transfer the case before it to the higher court. That is what we call it as certiorari. So certiorari is something like it is trying to prevent and it is also trying to cure, but whereas prohibition is only trying to prevent that particular situation from happening. So certiorari also can be exercised in case of judicial authorities, but at the same time it was also applied in the case of administrative authorities also. Now let us understand the last one, that is quo warranto. So what is quo warranto? By which authority? So for example, if a person has illegally occupied any public office, then this writ can be issued against that particular person, saying by which particular capacity or by which authority you have occupied that particular office. So this quo warranto is the only writ which can be even which can be filed or which can be actually entertained by any person who is not actually the victim. That means not only the aggrieved person, any other person in the interest of the society can also go for issuing or can filing this particular writ. Then we also have to understand this quo warranto is very much important because it prevents any illegal occupation of any public office, right? Then let us understand the difference between writ jurisdiction of Supreme Court and High Courts. So Supreme Court and High Court also have this writ jurisdiction. So we have under Article 32 for Supreme Court and Article 226 is for the High Court. But Supreme Court's power is original and it is also wider, but it is not exclusive because Supreme Court is not alone having the writ jurisdiction, it is sharing it itself with the High Court jurisdiction also. But High Court is having wider jurisdiction in terms of the ambit because High Court can issue writs not only for the enforcement of fundamental rights, but it can also be issued for enforcement of legal rights also. But in case of Supreme Court, the writs can be issued not for the legal applications, but only for the enforcement of fundamental rights. But when you see the territorial jurisdiction, Supreme Court's territorial jurisdiction is very high in case of enforcement of writs or fundamental rights, but compared to the High Court's jurisdiction. So these are the important differences between Supreme Court and High Court in terms of writ jurisdiction. Let us understand the practice question. Consider the following statements regarding Article 32. So you have been given 3 statements. Among this, which you feel the correct option, let me know in the comment section. And then as part of the concept of the day series, we have discussed about Article 32, most important Indian Constitution, article related to Indian Constitution, which our founding father of Indian Constitution, B.R. Ambedkar, has called it as heart and soul of Indian Constitution. So without this particular article or this provision in the Constitution, all other fundamental rights are meaningless. So that is why it is considered as very much important in enforcement of all other fundamental rights. So if you liked the video and found informative, let me know in the comment section. Thanks for joining. See you again.